Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu at Press Publications. Exercise number 3 and 4 on the speed of 90 words per minute. Start. Sri Raghavendra Kumar Singh, learned senior counsel for the respondent university, has invited the attention of the court to the entire material relating to parliamentary debates, the deliberations of the standing committee of the parliament, and the objects and reasons to contend that firstly, the university was established under a special act, namely the 1994 Act. The said act clearly provided for special reservation for scheduled castes, scheduled tribes, and accordingly, the first academic ordinances provide for 50% reservation to such classes. He therefore submits that this stood protected and could not be abrogated by the general provisions of the 2006 Act. His contention is that the 1994 Special Act continues to hold the field, and any exercise of framing of ordinances under the said Act that provides for 50% reservation could not have been taken away, for which the amendment in the 2012 Act came to be introduced. He submits that the respondent university, being a special university meant to uplift the cause of scheduled castes, scheduled tribes in particular, is fully justified in providing 50% reservation, which stands protected under Article 15(5) of the Constitution of India. He submits that even if the validity of the 2006 Act has been upheld, the same does not abrogate the provisions of the 1994 Act that can still exist independently and which now stands even otherwise protected with the 2012 Amending Act. He contends that the petitioners, having not challenged the competence of the Parliament or prayed for declaring the said provisos as ultra vires to Part 3 of the Constitution of India, the wisdom of the legislature in introducing the statutory limitations cannot be said to be violative of Article 14 of the Constitution of India. He submits that the provisos simply preserve and contain what was provided under the 1994 Parent Act of the University, and hence all the arguments advanced on behalf of the petitioners deserve to be rejected. He has also questioned the locus standi of the petitioners on the ground that reservation is not a fundamental right and no such rights can be enforced by the petitioners. He then submits that the university ordinances were also laid before the Parliament, and there is a presumption of the validity of the 50% reservation provided for in the ordinances. On the issue of interpretation, he submits that the provisos, if literally as they stand, carve out an exception which does not in any way violate either the main clause of Section 3, being an exception to the same, and once having been included, the wisdom of the Parliament or the reasonableness thereof cannot be questioned by the petitioners. He submits that the purpose of a proviso is to make a provision which, but for the proviso, would not be in the main section, and the same can also simultaneously stand with the main section. There is a presumption against implied repeal. As such, the 2006 Act does not override the 1994 Act, which is a special act. The aforesaid judgment dated 4/9/2015, rendered by Honorable Single Judge in the case of Mahavir Singh Supra, was challenged by the state of UP by filing special appeal defective number 884 of 2015, and the division bench of this court by means of its judgment and order dated 12/1/2016, while setting aside the judgment and order dated 4/9/2015 passed by the Honorable Single Judge, has observed that mere recommendation made in the said case by the Superintendent of Police for giving out of turn promotion did not confer any indefeasible or vested right of promotion. The division bench further observed that once the government order dated 7/6/2014 had taken effect, which has the effect of rescinding the office memorandum dated 3/2/1994, any promotion which is required to be made would necessarily have to be governed by the statutory rules which hold the field. The division bench thus held that a conscious policy decision has been taken by the state government based on the exigencies of the service, and in terms of the government order dated 7/6/2014, the office memorandum dated 3/2/1994 would stand rescinded, and that the scheme of out of turn appointments would stand substituted by monetary compensation. It is thus in the background of the aforesaid facts that the special appeal was allowed, and the judgment rendered by Honorable Single Judge in the case of Mahavir Singh Supra was set aside. So far as the law laid down by the division bench in the aforesaid special appeal is concerned, there cannot be any quarrel. However, what is noticeable here is that the facts of the present case and the facts of the cases which were subject matter of the decision by the division bench in the special appeal defective number 884 of 2015 are distinguishable. The distinction between the facts of the present case and the facts which were under consideration before the division bench in the special appeal lie in relation to the date on which right of consideration for grant of out of turn promotion crystallized in favor of the petitioner in this writ petition and the persons who were seeking out of turn promotion in the case of Mahavir Singh Supra. There is no dispute that all the matters which were decided by Honorable Single Judge by means of judgment and order dated 4/9/2015, though recommendations had been made for grant of out of turn promotion prior to issuance of the government order dated 7/6/2014, and the incidents on the basis of which such recommendations were made had occurred prior to the said date, that is, prior to issuance of government order dated 7/6/2014. However, in none of the said cases the matter was finally decided by the authorities in terms of the government order dated 3/2/1994. To the contrary, in the instant case, the decision was also taken for not granting out of turn promotion to the petitioner on 5/3/2013, which became subject matter of challenge before the UP Public Service Tribunal in the claim petition filed by the petitioner.